can make a local recording of the meeting and post that up on the website later. So people won't be able to follow live, but it will go up later. There'll be time between the people being able to see that and people having to do anything in consequence. It's helpful for people to be able to see the meeting online, because when I put the meeting note out next week, there'll be a deadline in that, so that 2 weeks from the date that the meeting note's posted, people who want to take part in later on parts of the process later in the year need to give me a definite confirmation of their intention to do that. But there'll still be time. IT are quite quick within a couple of days at getting these things posted up online. So anybody that's not here today and hasn't had a chance to watch live will still be able to have a couple of weeks to watch that meeting, see the meeting note and know what they need to do. So if anybody who isn't here today is talking to any of you about that, just direct them to the meeting note and the deadlines in that, and they'll be able to see the meeting in the meantime. Okay, so I'll resume, and we were just going to start agenda item 5, where we look at my initial view of issues requiring further procedure, and then we'll have a discussion on other people's views on that. So the purpose of this agenda item is to look at the further procedures that I've initially suggested using for each of the topics that I know I want to take more evidence on. I know that the Hoffwig Group's put together some additional suggestions, and I know also that the Council is keen to propose hearings rather than inquiry sessions for some of the topics. So we'll discuss all of those points under this agenda item. It'd be helpful, I think, if you had your agendas open at Annex A. I don't have a page number for that, but Annex A, there's a table where I've set out my initial suggestions and then a bit of the initial scope for some of those topics under there. I just wanted to stress that this indicative list that I've put together, it's not indicative of relative importance of different topics. It really just reflects where my initial thinking was on what I do or don't already have enough information on in order to be able to form advice and recommendations to ministers. So in preparing my advice, I'm going to be already taking into account all the environmental information, additional environmental information, all the consultations responses and all the representations that people have been provided. This is about additional evidence on top of that. Another thing I wanted to just point out initially is that you can see on here I'm proposing a hearing session on conditions. That's a very commonplace part of any inquiry into a wind farm. When I make my recommendations to ministers, I need to include in that a set of conditions. That's whatever I'm recommending, they should decide. Ultimately, ministers can make a decision that may or may not be in line with my eventual recommendation. So in the event that the proposed development did receive consent, there'd need to be a set of conditions to monitor and manage that. So my report wouldn't be complete without one. Anybody taking part in that discussion, those discussions would be without prejudice. So if anybody's talking about the content or the wording of a particular condition, that's not going to be taken to assume your content, that it should be consented. It's just what should a condition be in that eventuality. Okay. So I'm going to briefly recap on what each of the procedures involves just before we talk about what's right for each of our topics. So I've already mentioned under item 3, the Code of Practice explains what's involved in some of these procedures in more detail, and I've also included some brief information on that in my notes of the agenda. Just very briefly again to prepare us for this part of the discussion. In an inquiry session, witnesses give evidence and they're likely to be cross-examined by those who have opposing views. I might have questions for witnesses too. It's not necessary for parties or individuals taking part in inquiries to be formally represented. They often are, but often equally aren't. Individuals are very welcome to give their own evidence and to ask their own questions of the other party's witnesses. And inquiries are most typically used where a matter is particularly complex and technical, so where you need that extra bit of drilling into the evidence on either side. In a hearing session, there isn't formal representation and there isn't cross-examination. Parties' lawyers might still take part in those discussions, but they're playing a different role. A hearing session really takes the form of a structured conversation, which I would lead, so it's less formal in nature. Because of that, though, it can be less well suited where the evidence and the matters in dispute are more complex and more technical. Further written submissions are fairly straightforward, I ask one or more parties a specific question or for information on a specific discrete bit of information. That's answered in writing by those initial parties, and then other parties to the inquiry have an opportunity to add written comments on what the original parties have said. So I'm about to go through the inquiry, hearing and further written submissions that I've initially proposed in Annex A before widening out to discuss the additional suggestions that we've had. At this part of the agenda, I'm just looking for views on whether those are the right methods that are suited to the topics and to the evidence in this case. And we'll look later on in the agenda at who might be involved in those discussions, how much time we might need to set aside for each of the oral sessions that eventually agree on. So just before I moved on to the specific suggestions, are there any general questions about the different types of procedure? Nope. Okay. So if you look at agenda Annex A in my table, I've indicated initially 2 topics for inquiry sessions, one being landscape and visual effects and one being cultural heritage, and that would be specifically about the settings of Sunhoney Stone Circle and Christchurch Stone Circle and Standing Stone. That's because they are the subject of the Historic Environment Scotland consultation response. I'll start the discussion on landscape and visual impact. So when the time comes for me to take evidence on this, whether that's through an inquiry or a hearing, I'd be keen to focus on the effects of the proposal in its final form, rather than the earlier iterations, on the baseline landscape and the visual context. Underneath the table in Annex A, you'll see I've listed a few things that I anticipate hearing evidence on. The things I've got listed there are the geographical extent of significant effects, whether the effects are localised, mitigation, residential visual amenity effects, nighttime landscape and visual effects arising from aviation lighting. That's certainly not a definitive list, it's just some of the initial things that jumped out at me from my initial reading into the case. I've read a bit further into the submission still, obviously I've still got a lot to look at, but I anticipate evidence might also cover any potential impacts on specific areas or specific receptors. There's been some discussion, for example, on the Dee Valley Special Landscape Area, on some settlements, one example being Midmar. So that's just at the beginning of what we might look to talk about in there. So as I said earlier, I'm conscious the Council's requested that landscape and visual impact evidence in this case be dealt with through a hearing session. So I'll come to you in a moment to hear your thinking on that. And then I'll come and see if other people have a view on what's best inquiry or hearing for this topic. So can I pass over to you, Mr. Findlay?
Yes, thank you, ma'am. It's primarily what is going to assist you best, and as all parties have agreed under item 3 to the Code of Practice, it's ultimately a decision for you at the end of the day. We have 2 primary reasons for requesting a hearing session. The first is that is in the nature of the type of evidence. It's likely, I think, there are going to be 3 expert witnesses on landscape and visual matters. They will produce voluminous reports. I'm not going to be pejorative in that sense, but you'll get quite a lot to read. And in essence, in the Council's experience, it's highly likely that that element of your decision will be determined by your consideration of that material and your analysis of that material when you've undertaken your site visits, both either before and or after the inquiry. And whilst hitherto most landscape and visual sessions have been dealt with at inquiry, more recently, certainly in my experience, there has been a mixture of them being dealt with both at hearing and at inquiry. And in our submission, the hearing is a more effective way of dealing with it because it gets to the matters that are of particular concern to yourself, arising out of the extensive evidence you'll have from the 3 expert witnesses. So in our submission, and the primary reason is that that is the most efficient and effective way of getting you the information you need. The second reason is, we alluded to in our letter, is that the expert who provided the input to the council upon which the council has relied, he is not comfortable with inquiry sessions, for reasons I can go into if necessary. But we would need to instruct a new expert were we to have an inquiry session. We would prefer, for reasons of economy and otherwise, to remain with our current witness, Carol Anderson, who's a well-known and respected landscape visual evidence witness. But if that was to be your decision, then so be it. But in our submission, for both those reasons, there is a good reason to hold landscape and visual by hearing. And perhaps the last point I'd make is that parties' debates on landscape and visual impact of wind farms are a well-trodden path now. Perhaps in contrast, say, with cultural heritage, or I don't know whether noise is going to raise its head, they are less usually heard at inquiries, but landscape and visual is a well-trodden path, and it's very unlikely that the parties are going to raise anything different in principle or by way of approach. The issues are going to be the site-specific impacts and how they relate to what was likely to be an accepted approach. So those are our submissions.
Thank you. It's useful to hear the detail on that. On the second point, obviously, if I do decide to go ahead with an inquiry, it'd be beholden on me to make sure that was an inclusive environment for whoever is giving evidence, whether they're professional witnesses or not. And obviously, I'd expect everybody taking part to help and make sure that was a friendly and positive discussion. So hopefully, whatever I do choose in the end for this topic, your witness might decide they're able to take part. But we'll have to come to that, cross that bridge if we do come to it. On the first point, I guess that's really what needs to influence my decision the most, is am I going to get the information that I need ultimately out of whatever process we have. I'm interested, I was wondering whether there were any examples of where landscape and visual impact has been dealt with through a hearing in an application with sort of any similarities to this one that you're able to give me as an example now or later.
Perhaps I could do that later, potentially even today, but I would like to, I have been involved personally with a number of inquiries in Highland Council where that has been the case, and I can give you examples of that, either before this session finishes or immediately afterwards by correspondence.
Yeah, that'd be helpful, and if you could do that, if you're not able to do it today, if you could do that this week, then I'll be able to consider that before I finalise the meeting note. Could I take comments from the applicant on this matter?
Yes, thank you, ma'am. We agree with your suggestion of an inquiry session. Responding to Mr. Finlay, I don't agree. I think that landscape and visual issues are complex. They vary considerably from site to site. And I think that formal evidence, including cross-examination, will materially assist you in coming to your views. I rather feel with landscape and visual issues that more potentially comes out of an inquiry session through the examination process than comes out of discussion. Yes, it's a well-trodden path, but as I say, every site is different. In terms of the second reason given by Mr. Finlay, I'm sorry to hear that Carol Anderson doesn't want to give evidence of inquiry. She's a highly experienced witness who I've cross-examined more than a dozen times, and she's extremely good. If it means changing witness, so be it, but I don't think choice of witness should be the primary reason for your selection of the means of process here. I ask for an inquiry session.
Okay, thank you. And in terms of the specific evidence that we're likely to need to discuss and I'm likely to hear in this case, I don't know all of the matters in dispute yet, and that'll sort of crystallise as we go along. But in terms of what you think is likely to be discussed, you're sure that a hearing wouldn't suffice?
I can't say for certain. I never can. I think landscape character effects will be in contention, and those can be more complex than visual effects and require expert evidence of a different quality and calibre and require examination. In terms of the visual effects, I think particularly, and I'm sure Mr Campbell may have something to say here, that the issue of localised effects and policy 11E2 of MPF4 will come into play. And that, I think, your take on that topic will be materially assisted by a proper cross-examination of evidence of the expert witnesses.
I'll just go back to the Council. Is there anything at this stage that you can say on some of this, without going into the merits, anything on the nature of the type of the things we're likely to be discussing that you think would better support a hearing?
There's nothing, in my view, in our view, having considered the material, there's nothing in the material that that is out of the ordinary. Mr Trinick refers to the issue of whether effects are localised or not. That's certainly a well-known issue that needs to be debated. But there's nothing out of the ordinary that, whether it's in landscape character, visual impacts, residential visual assessment, or the application to policy, that requires a cross-examination. So, whilst in direct answer to your question, there's nothing specific that is going to be more suitable for a hearing in our submission. All of it will be more suitable for a hearing. I would make it clear that, in response to your comment about Ms Anderson and Mr Trinick's, that as far as I'm aware, it's neither being cross-examined by Mr Trinick or by myself that has led Ms Anderson to her view. But I'm afraid that it's, having spoken to her about it on a number of occasions, it's not just one that has arisen in respect to this inquiry. So, whilst I put my reasons first and second, and I know Mr Trinick did say the second reason was should have no weight, I put them there in that order for good reason, but if it is an inquiry, we will be needing a new witness.
Thank you. I have chaired an inquiry when Ms Anderson gave evidence, so I hope also it's not me. It's narrowing down. Okay, Mr Campbell, I wonder if you had any thoughts on whether an inquiry or hearing was best?
Yes, ma'am. I've set this out in my process list, which I sent you, and I'm in agreement with your initial, it's not a determination, but your initial view expressed in Annex A. I find myself awkwardly in complete agreement with my learned friend, Mr Trinick, perhaps for the only time in this inquiry, for the reasons that he gives, and in particular the peculiarities of this landscape, which of course is unique to this area. We feel that more will come out of cross-examination than out of a conversation. In addition, the preliminary advice I've taken from my expert, who is retained now, is that there will be criticism of the methodology employed by the applicant's expert. It's marginal criticism, but nevertheless important. And so it's important that you understand those differences in order to enable you to take a view once you've done your own site inspections. I'm not going to dwell on whether or not it's complex evidence or simple evidence, because that wouldn't be appropriate today. But you can take it from me, I think, on my responsibility, that that there's a serious line of cross-examination to be followed, and in due course, Ms. Platt, who is the expert, will produce her inquiry report. So we are strongly of the view, with respect to my friend Mr. Finlay, that an inquiry session is appropriate. And taking on board Ms. Anderson's inhibitions, whatever they are and whatever the cause of them, I don't think I'm the cause of them. And I'm quite confident, ma'am, that you would ensure that the inquiry session would be conducted in a proper, decorous way.
Thank you. I would. I'm assuming Historic Environment Scotland don't have a strong view on this, but I'll just check whether I'm right and wrong.
That's correct, ma'am. No view on landscape and visual impact.
So does anybody else, including any of the community councils, have a view on whether an inquiry or hearing would be the best way to discuss landscape and visual impact in this? Or are you happy for me to decide based on what I've heard so far? Any hands up? Yeah, Mr. Ross.
The only thing I would say is that the inquiry process would obviously be far more intimidating to community members who are not learned colleagues than to others. So just make a plea, if going down that route, that it's as easy to contribute to for members of the community as possible, so that we can represent the views of the people who live here.
Thank you. Yeah, I'd certainly try and make sure everybody involved felt, they were an equal part of that and able to contribute. And I've held inquiries before with community representatives contribute to a formal inquiry, and it, that can work well.
I just want to underline what you're saying, that the current way of thinking of these matters is not to treat inquiries like a criminal court and to treat lay witnesses with respect. It doesn't stop them being asked questions, because they would expect to be asked questions, but the corollary is also true. And certainly in my experience, and I'm sure both of my own friends, the lesson has been quite hard. It's been learnt over the years that criminal court behaviour doesn't work, and it isn't encouraged.
Thank you.
Mr. Campbell's looking at me, ma'am. I will cross-examine expert witnesses, but if someone wants to offer their view as a member of the community, I don't cross-examine.
Yeah, and that's in line what I've seen where community witnesses are taking part. People do respect that that's a different experience for you, and if questions are asked, they can always be asked gently or clearly. Okay, so I will move on to the cultural heritage topic. And I've proposed an inquiry session on cultural heritage effects here, but I'm open to hearing views on whether that's the right approach in this instance. So this session would be specifically on the setting of Sunhoney Stone Circle and Christchurch Stone Circle and Standing Stone. I think that's the key issue in focus in the Historic Environment Scotland objection. So I will take views now on whether inquiry is right for that topic, and I will start with you, Historic Environment Scotland.
Thank you, ma'am.
I'm just going to pause, I think. Yeah. Sorry, I'll try and speak more clearly and closer to the microphone.
Thank you, ma'am. Historic Environment Scotland would respectfully agree with your preliminary view on further procedure, and that an inquiry session is appropriate for consideration of cultural heritage. It's considered that an inquiry session would be, again respectfully, of most assistance to you. Historic Environment Scotland's preliminary assessment is that the evidence of the applicant's expert will require to be tested by way of cross-examination. It's also our understanding that Mr. Campbell is intending to lead an expert at the inquiry session. at whatever session is fixed to deal with cultural heritage. So, ma'am, you may have the evidence of 3 cultural heritage experts at that session. Cultural heritage, as has been foreshadowed by Mr Findlay, is not something that comes up particularly often. It's not perhaps as familiar territory. Ma'am, you may have considerable experience of dealing with cultural heritage objections, but Historic Environment Scotland objects sparingly. Integrity of setting as a concept is something which has been considered at a handful of inquiries over the past number of years, and it will be, I would submit, of considerable assistance to you to have each expert's application of the relevant policy in the context of both of these assets interrogated in a way that really can only be achieved at an inquiry session. That's certainly Historic Environment Scotland in the handful of inquiries in which it has been involved over the past couple of years. Thank you, ma'am.
Okay, thank you very much. Council, I think your preference for hearings was that specifically landscape and visual impact? You didn't have an objection on this?
Yes, it was, and indeed Milne has picked up my point correctly in our submission. We've made it clear that our cultural heritage objection mirrors that of HES. We're not proposing to court separate evidence, and we're relying on HES, but I would support them in their application for a inquiry session. It is not a matter where, in our submission, that it's not at all similar to landscape and visual impact. An expertise is required to undertake the assessments, and that is better teased out by way of a proper inquiry session.
Okay, and Mr Campbell, I think you were supportive of an inquiry.
Just to confirm that we've instructed and retained an appropriate expert and would hope to give evidence at an inquiry. I agree otherwise with Mr Finlay. Of course, we're reliant to some extent on Historic Environment Scotland, but this person is an author of an appropriate textbook and, as far as I can see, has the appropriate expertise to assist you.
Thank you. And just before I come back to the applicant, is there anybody else that wants to say anything on inquiry versus hearing on cultural heritage? No? Okay, Mr Trinick.
Yes, ma'am, we agree with an inquiry session for the reasons Mr Milne has put very well. We agree with what he says. Just 2 points. Firstly, there are 2 aspects to cultural heritage: impact, and then there's the policy. But I would imagine the policy issue can be dealt with in the policy hearing session rather than in an inquiry session. That's a question to Mr Milne. And secondly, I just note quietly that I think the position of Aberdeen Council is very reasonable in this case.
Okay, Mr Milne, did you want to comment on that split of policy?
Yes, grateful to Mr Trinick for raising that point. Mr Trinick and I had a brief conversation about this. What is anticipated, ma'am, if this meets with your approval, is that impact will indeed be dealt with at the inquiry session with Mr Trinick, Historic Environment Scotland, Mr Campbell leading their respective witnesses under cross-examination. But as regards policy and looking at relevant precedent, then that will be dealt with at the policy session. So Historic Environment Scotland would intend to participate in a policy session where it is certainly thought that a hearing would be the most helpful thing to you to explore the issues around the application of policy in this context.
Okay, thank you very much. Does anybody else want to have any extra points on this? No? I'll move on then to policy and conditions hearing sessions. So as well as the topic-based landscape and visual impact and cultural heritage sessions, see from Annex A in the agenda, I'm also proposing 2 other hearings, one on policy, one on conditions. Those are both very commonplace components of inquiries for wind farms. Does anybody have any comment at this stage on my proposal to have a policy hearing and or a conditions hearing? I'll just take a raise of hands because doesn't generally raise as much debate. Yeah, Mr. Campbell, are you happy with that approach?
Yes, ma'am, thank you.
The other hearing session that I've flagged would be, it's called a hearing, it's a slightly different type of session, a community hearing session. There's obviously a lot of community interest in this case, so I've anticipated that there might be appetite for a dedicated session where community voices in particular can be heard on a range of topics. And that would be, the idea behind that would be to let people speak about matters that aren't being examined in detail in an inquiry or a hearing session. I've found in the past that community sessions can be useful to help reaffirm some of the key points people are raising in their letters of objection or support. They can even help crystallise some concerns, make them a bit clearer, and make the reasons and the background to them a bit clearer. That's particularly the case if the format for the session included me asking questions of the participants and being able, if I need to ask the applicant questions based on what I've heard. So that would be very much a less inquisitorial session, even than a normal hearing. But I think they can play a useful role, especially whereas here there's quite a lot of people from the community, whether that's individuals or community groups who are willing to take active part in the inquiry. So I'm interested to hear, particularly first from community participants and individuals, whether that sounds like something they might have an appetite for, that might be helpful here in addition to those more formal sessions. Can I come to you, Mr. Campbell?
Thank you, ma'am. I'm advised that there is an appetite for an evening session of community contributions. I'm not in a position to tell you yet how many people would wish to be involved or what topics they would wish to address you on. But I'm told that there is a demand. And of course, I'll take time between now and whenever to straighten that out so that you have a clear idea of what to expect. We can also offer to assist the community councils in this regard if they wish, but of course they are not represented by me today, and therefore it's simply an offer on the table at the moment.
Yeah, thank you very much. And yeah, for this part of the agenda, I'm really just looking for confirmation that that would be a useful thing to include in our programme for later in the year. Would anybody from any of the community councils like to speak? Yep.
Yes, I would agree that it would be helpful to have a community hearing session. Thank you.
Thank you very much. Any other community councils? Yep, Mr. Argyle.
Oh. Yeah, thank you very much. No, just to confirm, we would agree as well, and would thank Mr. Campbell for his kind offer and for assistance.
The concerns for Midbar residents are primarily around private water supplies and the disturbance of the uranium that's known to reside within the hill. We regard this as extremely important for my constituents, and we would like to elevate that up to a hearing if at all possible.
Okay, we'll come onto that because I think that's one of the suggestions that Hofwig have made. So we'll come on to additional suggestions at the moment. If it wasn't the subject of a specific hearing, then a community hearing session would be something that additional concerns like that could be raised at. So it would be a home, if you like, for anything that's not already been discussed. But I think we are going to talk about that issue later. I'll just look for a show of hands, maybe from people sitting down the side here who are individual potential speakers, whether any of you think that would be helpful, just a general idea at the moment. Okay. And equally to people sitting in the rows towards the back, you know, that might be something that other people who are opted into the inquiry but not speaking today might find interesting to attend certainly as well. Yeah, it looks like that would be popular. Okay.
I wonder if I might add one thing.
Yes, sure.
I've been passed a note which makes it clear that all of the community councils, each of the community councils has taken up a position in relation to this application, which is to object to it. And each of the community councils has agreed to work with Hofwig to present those views to the inquiry. So to that extent, Hofwig can say it has a certain democratic mandate. And whilst I think the community council would stop short of calling themselves my clients, they're as close to that as makes no difference.
Okay, thank you. That's helpful. I mean, I've got when we come on to the part of the agenda where we talk about who takes part, I certainly generally encourage people to see if they can group together, because I think you can get more out of the inquiry time that way rather than otherwise you can have repetitive evidence rather than, you know, you might be able to draw points out more.
At a time that everybody in the community
Yeah, that's fine. So the request there was that if there's something, particularly something that's specifically focused at the community and trying to get community involvement in, that would be not during the working day. I think Mr. Campbell made the same point earlier. I've got a point on the agenda to discuss that, but I'll take that as a view. I'm sure that'll be quite a common view and one we could accommodate. Just looking to see if there's anybody else who wants to speak about the community hearing session now before we move on. I was going to go through the further written submissions that I'm going to ask for. Sorry, I'm moving my mic back and forth a bit because if I put it closer to me, I know you can hear me better. But I do sometimes get a bit of feedback on the speaker when I'm not speaking, so I'll just try and move it back and forth and do my best. I'm going to come on now to further written submissions. So on Annex A of the agenda, I had flagged up a few topics that I intend to ask for further information in writing from. They are radiation, peat, although that is more of an informal clarification question, radar and shadow flicker. So do people have any questions on my proposal to ask about that? Mr. Trinick.
Thank you, ma'am. Can I go broader than that? Because I refer also to Mr. Campbell's very helpful note which he circulated prior to this meeting. And in that note he asks for oral process in relation to 7 matters in addition to those we've discussed already. And what I say applies to his request as well as to your suggestion for written submissions, and it relates back to my suggestion that we actually have a 6-week period for written submissions rather than 3 weeks. And my suggestion is this, that rather than try to make a decision on whether or not oral process is needed now, I think we need to go through a written exchange in advance, because I can't tell from looking at the reasons which Mr. Campbell gives, which may be very good reasons, I don't know, but I can't tell exactly what divides us, what are the issues we need to have evidence upon, what precisely are the issues in play, and we need to discover what those issues are so that you can decide appropriate process. So my suggestion is that for each of the 7 issues, there should be a written exchange within 6 weeks with answers as laid out in a further week or whatever to the written exchanges, so that you are put in a position to decide what process is appropriate. And those submissions can obviously make the case for whatever process is proposed. But I think that might be a better way around it, because at the moment I'm looking at some of the 7 issues and thinking, I can't tell whether oral process is needed or not. I don't know yet, but a written exchange will tell me. So that covers all of the written submissions, frankly.
Okay. So on the written submissions that I've flagged, I know what the questions would be now. I guess what you're saying is it might not be as clear what the additional potential questions are. What would normally happen for further written submissions would be, if I look at the information behind the requests for additional process that Hofwig have submitted, if I felt there was a question within that that I needed answering, I'd formulate a question and ask. If it was a written submission, I'd formulate a question, ask a question, and then get the responses. Are you suggesting it might be that there needs to be an initial exchange in writing in order to decide whether then a hearing might additionally be helpful on some of those topics?
Yes, I am, because just for example, on the carbon calculator, a number of points are made, but I can't tell from that very clearly, and maybe because I'm not reading it correctly, what exactly are the issues which are in debate here. And the same goes for ecology and forestry, same goes for ornithology, and to some extent socioeconomics. It may be that oral process is appropriate. I don't know yet, but that process of written exchange should flush out the issues and tell us what needs to be addressed, and whether what needs to be addressed can be dealt with in writing or needs oral process. I think that would be a more efficient way of proceeding, rather than coming to a view now on what's needed, because I can't tell you what's needed now.
Okay, so you'd still be anticipating a specific question coming from me in the meeting note on these issues. What, you mean that, rather, you mean something a bit looser?
No, I think in relation to those submissions you've already identified, you must have identified what you want to know. That's why it's there. But for the additional points made by Mr. Campbell, it's not so easy to tell exactly what is required and why. Therefore, my proposal is the parties exchange views on what is required to deal with the issue. We're then given a further week to respond to those submissions by the other party or parties. That puts you in a position then to decide what do we need. Do we need more process at all? Do we need written process? Do we need oral process? And if so, which? And you can then decide.
Okay, thank you. Mr. Campbell, can I hear your thoughts on this?
Yes, thank you, ma'am. I'm grateful for the summary of my learned friend's position. Uniquely in this case, the objector group did a lot of work before it instructed any legal help. And you will have seen amongst your papers what I've come to call the Orange Book, which is a compendium of objections beginning in January 2024 and has been subjected to 2 updates, one I think in July and one in September 2024. And those 3 documents taken together, I think to an extent flush out the issues which are now the subject of our conversation. In addition to that, the process document which I submitted to you earlier this week contains a very truncated summary of what I take to be the issues in front of you. So it's quite possible for my own friend, if he looks at all of these, to see what the issues are that are concerning the community or those experts which the community has already instructed. Now, I'm sorry, but I'm not persuaded that a statement of case type document in advance of your decision as to what mode of examination is appropriate is really going to be helpful. When we see statements of case in matters of this kind, we see each party setting out its pitch, if you like, and what we'll see is largely repetition of what you have already, probably tidier, probably less ragged around the edges, and that will be met with a response from the applicant saying something like the opposite. So you're faced with two competing bodies of evidence, and my own friend supposes that this will flush out the issues to be discussed. Well, the issues to be discussed are already on the table, because what's in the orange document, of course, is drawn from the environmental statement and from the supplementary documents, such as, for example, the planning statement, the public consultation statement, the design and access statement, and so forth. So you really have what my own friend is already asking for. What I would respectfully propose is that you simply elevate these topics to hearing sessions, which would require hearing statements to be submitted in advance of the hearing, and then allow a discussion of the points in issue which would be necessarily raised by the hearing statements. And it's, I think, axiomatic that a hearing, or indeed an inquiry session, I'm not suggesting that in these cases, a hearing is the best way for a reporter to, A, make the parties aware of what she wants to know, and B, for the parties speaking informally, not through lawyers, but speaking informally with community representatives or appropriate experts, to let you know what they think about the particular issue. If we may take an example, just for the purpose of this submission, if we may take an example of the first one on the list, ecology and forestry. There's a series of points set down on the page of my process list, which we think are in issue already, and that those points are drawn from what we find in the Orange Book, what we find in the environmental statement, and what we know locally and have drawn from local evidence. Of course, I can do a hearing statement, I can do a statement of case in advance. That's quite possible, but it seems to me that it's not a labour which would necessarily result in a product that would help you any more than a hearing statement would. You could timetable these statements so that they are, for example, half-day hearings. You could timetable these hearings so that they are, for example, half-day hearings or 2-hour hearings, and that way force people to concentrate in presenting their evidence within a time frame. Because there's nothing that lawyers hate more than a time limit. But, of course, if we have to make our clients comply with the time limit, then they will. And that's quite a good use of, I would suggest, quite good use of your inquiry time if you're going to be here for a week anyway.
Okay, so just to clarify, your view would still be that for the topics you've asked for a hearing session, you still think that's likely to be necessary?
In my submission, yes.
Yeah. And for the applicant, are you essentially saying you wouldn't be able to form a view on that without seeing a more formed summary of the reasons for that, or that you, I guess you don't think I could maybe make that decision at this stage?
Well, as I said already, we don't know yet. We have read the Orange Book, obviously, we've read it. But all oral sessions are time-consuming. Half a day here, half a day there, and suddenly you've got 4 days or 5 days extra on the inquiry. That's very expensive, very time-consuming for everybody. The process I've suggested will narrow down the issues. There are always a broad range of issues when you start, and they narrow themselves down to what really needs to be debated. And the process I've suggested will narrow down the issues, and it will tell you also what's required, because for some of these issues, for example, radon issue, you may decide that a hearing session is inadequate to deal with such a technical topic, and you might require an inquiry session. You don't know that yet, I don't know that yet. And the flushing out process, which I've suggested, will flush that out and tell you. It will make the inquiry run much more efficiently, because we will only be using time and oral process which is really required. And it will tell you whether you can get the evidence through a hearing session if oral process is needed, or if you really do need cross-examination. As with noise, for example, I don't know at the moment how much noise is in dispute apart from the decibel level, but if we are into technical evidence on noise, then it may well be I'll be asking for an inquiry session and not a hearing session. But I don't know yet, and I can't tell you.
And so when we come on to a later agenda item, when we're looking at how much time we need to set aside for process, we would need to provisionally look at if hearings did come out of these suggestions, which I won't decide on today. I'll decide on that. I'll reflect on that and decide later. But we'll need to remember to pick that up in the potential programme time later. So just whilst we're on this item, were you anticipating that they would be essentially hearing sessions just between your group and the applicant?
Detect my learned friend Mr. Finlay or my friend Mr. Milne having anything to say about any of these points, but of course they're welcome to intervene if they do. So yes is the answer to your question.
Just to clarify the nature of what you're suggesting at this stage.
I mean, everybody has their own way of doing hearing sessions, but for what it's worth, mine is to put the witnesses in the front seat and for the lawyers to take a step back and let the witnesses make the case to the reporter directly and answer her questions when they come.
So I'll maybe just say a brief word about the further written submissions that I'd marked down myself and the nature of those, because it might help then. It might help people thinking on whether that approach might help on some of these other topics. So I had flagged up two of the questions I flagged up are responses to things that I've seen raised in objections, and I don't necessarily know the detail of the applicant's view on those. So one of those is the issue people have been raising about radiation in the geology and potential impacts of that. It would do just to give the applicant a chance to comment on those comments. Similarly, shadow flickers raised a lot in objections. A small number of the objections go into detail or ask questions about methodologies for assessing shadow flicker. So again, it would be, I was envisaging a question asking about that. The other two that I flagged, radar. So we don't have the airport or NATS with us today, but that was more a clarificatory question for me to understand a bit more behind their objections. So at the moment, there's objections from the airport and the NATS relating to flight instrument procedures and radar, and it was just a little bit to be able to just to make sure I can articulate that properly, the reasons for that properly in the report. And then there is a question of clarification on Pete. So when I looked initially at these suggestions from Hofweg, Mr. Campbell, one of the things I'm wondering was whether they might be similar territory to the shadow flicker and radiation situation, where there might be issues that have been raised in objections, quite common issues raised in objections, that would be helpful to have some further information from the applicant on. So part of my thinking after the meeting, when I decide what process is needed, will be whether they could be dealt with in a similar way. If you've got any comment on that.
Forgive me, but by in a similar way, do you mean in writing?
Yeah, a further written submission to ask the applicant to comment further on the issues that are still in contention.
Well, I see the drive for that, ma'am. Clearly, radiation and uranium and radon, as it's described in a number of places, is a bit of an esoteric topic. I have, however, been lucky in locating an appropriate expert who is now in the process of informing me about whether or not there is a sensible argument to be made in the context of a Section 36 inquiry. Obviously, exposure to those matters from excavation for pylon, for turbine bases, is what this is all about, really. I'm not yet in a position to inform you about what my expert advice will say, so that's obviously not very helpful today. But nevertheless, I'm on track for finding out about it. Taking the second point, shadow flicker suffers from a sort of terminological difficulty. It means different things to different people. Mr. Turing would say, as I've heard him often say, that it's confined to the phenomenon where the turbine is between the sun and the small window in a house, and a stroboscopic effect is achieved, which is potentially dangerous to epileptic people and also extremely disturbing. Others say it's just the casting of the shadow by the blades over a long distance. We live in a part of the world here where over the winter the sun is very low and it crosses the horizon very slowly every day when it's shining, of course, with the turbines between houses and the sun. People call that shadow flicker. May be wrong to do so, but I call it shadow cast. Nevertheless, it's a disturbing phenomenon.
I've tempted you into details, I think. And what I was really meaning was, and I expect the answer's probably no, but you tell me for yourself, I'm assuming at this stage you don't think that topics on this list, unless you've said for writing, you feel there's more to them than would be suited to a simple written exchange. Is that right?
Not quite. I do in respect to the first. I don't really feel strongly about the second one, although those that suffer from shadow cast do. But I accept that we know where the sun's going to be every day, and therefore it is a matter of calculation. In respect to the third matter, we don't have a view on either radar or National Air Traffic Services. I have seen a letter dated today or yesterday from Aberdeen Airport who say they're in discussion with the applicant, and that's a matter for them. I'm not representing them. But like you, I'd expected to see them here this morning, and they're not coming. And in respect of Pete, ma'am, I don't have appropriate expertise to bring to the inquiry, at the moment at least.
Well, I'll have to take that away and think about it. So I see a hand up behind you, Mr. Campbell.
Ma'am, if it's okay with you, I'd like to say a couple of things about that might influence your decision on how you approach the PEAT and the policy which are on the Hofrig list.
Okay, I'll let you do that, but just try not to, if you try and keep it procedural and not detail, and I won't have to come and stop you.
Okay, procedural. So I'm trying to put the case that you might decide on these issues now rather than have to see more information. With regard to Pete, the Pete and the planning balance, which I think comes under policy, are both related, relate to the purpose of the wind farm and the benefits that it brings. So because it's built on peat, it means that a lot of carbon dioxide, carbon, is put into the atmosphere before the benefits of the clean power come through. Now, the calculation is therefore important, and that calculation, the applicant has put forward the efficiency of the amount of electricity that is the most that it could possibly produce without...
Yeah, I'm just interjecting because I've seen that in the written representations, and I've seen that in the summary and the submission from Hofwig, and we shouldn't repeat it today, but...
I apologise.
Yeah, I picked up that there is more to the suggestion from Hofwig Group on peat than I would have had in mind initially for my peat suggestion, so that's something for me to think about.
So it's simply that it's very, very important to the function of the wind farm and to the planning balance, so therefore that these might be considered requiring a hearing or an inquiry rather than a written submission.
Yeah, so I can see that's something to think about. And I'm not going to make any decisions, certainly not going to make decisions on issues today, but there's quite a lot for me to think about in terms of what's the best way forward on the additional suggestions. So I'll think on that after the note and then confirm what I've decided when the note comes out next week.
Thank you very much.
Does anybody else want to say anything on the potential for additional procedure beyond those that were in my annex? Mr. Findlay, have you got any comments? No. Mr. Trinick, you've said what you'd like to say.
I want to come back on your annex, but not on the additional matters. We've dealt with those. On Pete, I think you've now seen the email from SEPA of the 14th of April, formally withdrawing its objection. I think you've seen an email recently, April anyway, from the RSPB saying it does not intend to attend the inquiry or I think contribute to the inquiry at all. In relation to radar, we are indeed in discussions with Aberdeen Airport and with NATS, and anticipate that agreement will be reached and that objections will be withdrawn. I can't say there will be, but that's the direction of travel at the moment. Thank you.
Yeah, and as Mr. Findlay, sorry, not Mr. Findlay, Mr. Trinick and Mr. Campbell have noted, the airport aren't here today and NATS aren't here today. I think that's really just a consequence of moving to in person rather than online. They've still got an interest in the inquiry. Both of them, I think, do anticipate there'd still be some need to discuss their position, and both, I think, are likely to want to be involved in the conditions hearing when that comes up. So I'll just share that, as they've just emailed that to me. Okay. Beyond what I have flagged in Annex A and the additional suggestions that Hofwig has raised, beyond that, I would deal with, consider and make recommendations on other topics based on what is in the written information already before me, without further procedure. So if something hasn't been discussed or isn't on the lists we've talked through today, it doesn't get ignored. I just work on the basis of what's before me.
May I just raise one topic before you move on? We didn't discuss the socio-economic chapter of the evidence. What I put in the process note is a very truncated version of the evidence I have begun to receive on this topic, and is clearly regarded, it's the last topic but one, I think, or the last topic. The last topic. This is regarded locally as being extremely important. And so what I had to say earlier about a hearing for this topic applies in particular to that topic. And I would urge you, when you're deciding to what mode of examination to take up, to look carefully at socioeconomics and see what is said. New stuff's coming up all the time, and it will have to form the basis of Hofwig's evidence on this point, whatever form it takes.
Okay, thank you for
Just to note on that, under socio-economics, there's also transport raised. I'm not sure if that's part of the socio-economic case or a separate transport issue.
Mr. Campbell, are you referring to transport as something that has a knock-on consequence socio-economically or separately in its own
Well, I felt
right?
it was appropriate to embrace it within that chapter and not to deal with it separately. You can see what's said there. I don't want to repeat it now.
Okay. It's under the, I mean, I'm seeing it under the title socioeconomics, so I would be assuming that you mean it as a socioeconomically relevant factor rather than a transport factor. So if I shouldn't assume that, then just say so.
I think, with respect to Mr. Trinick, you should see it in that way.
Can I raise one matter just?
Yes, please.
Before we move off, Mr. Trinick has indicated that they've withdrawn their objection by email, I think, 4th of April. You have in your note a point for clarification about whether our objection relied on the previous SEPA objection. It did. We were, I don't think, aware of SEPA withdrawing its objection, but if, I've no doubt, Mr. Trinick is entirely correct. If that indeed is the position, we will clarify with you, and it's likely that our objection will be withdrawn.
Okay, that's what I was anticipating. So I'll include, as I said, a question just to allow you a space to provide that clarification. It won't be a formal written submission, so it might be just on a shorter by return timetable.
We'll try and do that as soon as possible, because it may well be it's lying in someone's inbox. And indeed, if Amy Howard forwards that to Rob McIntosh, we may be able to confirm that to you by email today or tomorrow.
Okay, thank you. So if I get that beforehand, I won't cover it in the note. If I haven't, I'll put a reminder in. Okay, so I think we're at the end of this agenda item, which is item 5. Does anybody else want to say anything about process? Oh, Mr. Campbell.
Sorry to come back. I wonder if you'd consider asking the community councils whether they have anything to add in this section before you move on.
Yes, I was just going to ask.
I haven't had direct instructions from them.
I was just going to ask everybody, so I'll start with the community councils. Do any of you want to say anything about what topics we examine and how?
I thought I might just say something on the topic of socio-economics, because I'm not entirely sure what comes under that. Obviously, it is a major concern for the local community, the impact on, dare I say it, things like house prices or on the tourist industry, etc. And to have it dealt with in just, well, under the column no further procedure, I wasn't sure whether the community would be satisfied with that. That's a question.
Yeah, so I hadn't picked up anything specifically that jumped out to me to ask a question on, but Mr. Campbell has suggested that there might be more in that warrants discussion beyond what's already down in writing. So I'm going to be going away and thinking about what he's said and what he's submitted in writing and deciding whether I ask for more information on that. So I'll just note your community council thinks that that is an important topic too. Yeah, essentially.
Yeah, fine. That's like so. If I understand this correctly, you'll then reconsider whether this should be moved into a different category. Is that right?
Yeah.
Potentially a hearing.
Yeah. I reconsider whether, rather than no further submissions, no further procedure, there should be, and what it should be.
Fine.
Yeah.
Okay. Thank you.
Okay. Does anybody else from a community council want to ask anything? Yep. Mr. Ross. Sorry, I haven't got my glasses on, so I'm squinting.
I'd just like to point out that the radiation issue that you're inquiring about, the applicant completely failed to identify that as a hazard. It's incumbent on them to identify all the hazards they're likely to encounter. They were warned about this previously, and it's common knowledge in this area, and is in various reports, that the hill contains large amounts of radioactive material, but it doesn't feature anywhere in the EIA, and that's despite letters to RAS to warn them about it.
Okay. Yeah, so that's in line with what I've understood from what I've read so far in the case, and that's why I wanted to write and ask the applicant specifically to give some comments on that. And when they do, then yourselves and other people will be able to say in writing what you think of what the applicant said. So there would be something on record as a consequence of that. Do you want to say anything on that at the moment, Mr. Trinick?
No, thank you.
Order written statements on any of these topics, any of the, I think, 7 topics. Are you anticipating that there would be an opportunity to respond given to the applicants? And are you anticipating that it would be open to those taking part in that process to ask you to, as it were, change the mode of examination?
Yeah, so anything that I ask for a further written submission on, I'll be clear initially who I want the information from and what I want and when by. Then there will be an opportunity for other people to give me comments in writing on what they've seen. I would, in any case, if something arose that I saw that I thought meant I needed either, a further exchange or a discussion on, I might make a decision on that myself, but equally people have that opportunity to say if they I would want to know in writing what people thought. I wouldn't want them to just say, I want a hearing, but people can make that comment as part of that response. Okay, so are people happy to move on from this agenda point? Mr. Ross.
I just wanted to agree with my community council colleague and Mr Campbell on the socio-economic point. It would be a great disappointment to community in Banchory if there was no further procedure on that. The major issues coming to us are the landscape and visual impact and the socio-economic impact. So if there wasn't an opportunity then to submit further to you on that specific topic, it may be that all of that then comes up in the community hearing, which is possibly not the best place for that.
A community hearing, I mean, it would be a potential home for anything that hadn't decided to have further process on, but I'll note your comment there that you don't think the community hearing would be the right place or the right only place for that topic. Okay. Okay, I'm going to take a short break before we move on to the next agenda point. So when we come back, we will be talking about who would participate in the different sessions. Sorry, Hofwig.
Just a quick one about transport. Transport and socioeconomics and community distress. This is a much bigger issue than people take for understand, and I think there should be an opportunity to speak about that at some point. The written submission has already been submitted in the Orange Book for the community. However, I think there needs to be an opportunity to air that subject in a simple way so that people are aware of what it means.
In terms of community distress, I guess some of the issues that are major issues in community responses would be covered, and even if I only did what I'd initially suggested, some of those are covered. So there's shadow flicker and the residential visual amenities, residential visual impact, for example, but the community hearing would be there as well for other things that are of concern. So certainly I would expect there to be various places in the procedure where issues that are at the heart of what communities are saying will have a place to be discussed and heard. Okay.
Thank you, ma'am. That's very helpful.
Anything else that's coming to people just before I do move on? Okay. Yep. Did you have your hand up, Ms. Bick? No. Okay. Break. And when we come back, we're going to think about who might want to participate in the different inquiry and hearing sessions that we might have. So there'll be an element of speculation about that because we don't know exactly what inquiry and hearing sessions we have. But this will be helpful when we come on to discuss how much time we need. If we plan out, if we had all of the ones that are in potential contention, who might be involved, what that means in terms of how much time overall we might need to set aside. So you might want to think about that or have some chats in the break. So it's 7 minutes past 12 now. I suggest we come back at 25 past 12 and resume. Hopefully that's enough time. Thank you very much so far. Us up again. We're on agenda item 6 now, which is a discussion on participation in inquiry and hearing sessions. I've got further written submissions too, but particularly the inquiry and hearing sessions that would be useful to focus on. What I really want to know is just who at the moment thinks they might be interested in actively taking part in giving evidence at inquiries and hearings when we have them. Mr. Campbell's already mentioned that there'll be scope for some groups and individuals to work together on preparing evidence and speaking through sort of a channeled number of people rather than everybody feeling they have to take part individually. That certainly helps make better use of inquiry time and hearing time for people, and it also means that everybody's busy. You can focus on specific things. So I'm grateful that Mr. Campbell's started some discussions on that. I'm going to start with landscape. I'll start with the 2 inquiry sessions that I'd put down, and then we'll go through Mr. Campbell's list. I apologise to people who were just here observing because I had meant to list the issues that Mr. Campbell's group was interested in, and I didn't. So that might have been a bit hard to follow. So in this section, I'll make sure I'm clear which additional topics the community groups are suggesting that we talk about. So we'll start with landscape and visual impact, though. Obviously, I'll need to hear from the applicant and the council on this, and Hofwig are going to contribute to that as well. They've already confirmed. Other groups and people might want to give evidence on landscape and visual impact, whether that's through Hofwig or through a community council. So I'm interested just to see at this stage who thinks they might want to give evidence, whether that's a hearing or an inquiry. Can I have some hands shown? Mr. Harrington.
I'm just looking at my other Community Council colleagues here, but I think our agreement was that we would come to this hearing, reconvene, and then have a discussion about who might or might not want to present at the following sessions.
Yeah, and that's fine to have that confirmed later, and it's fine to refine it down later. The reason we sort of have it on the agenda partly is so that when I come to guess how much time each session might take, I've got an initial idea of, if it's an inquiry, how many witnesses there might be, for example, because that affects how many days we need.
I mean, I think the intention is that we want to avoid repetition, you know, people turning up and saying the same thing, so that would be, we would reduce that to a minimum.
Okay, thank you. I'll maybe come back to some of the groups sitting nearer me and see, for the council, for example, how many people you expect to have involved in an inquiry or a hearing.
Well, it may assist everybody if I just deal with our whole attendance. Cultural heritage, we've indicated we're not going to call a witness, but Mr. Brown will be here throughout that session. Indeed, someone will be here from the council throughout any session. Landscape and visual, whether it's a hearing or inquiry, we currently propose to have one witness. And at policy conditions, we'll have one witness. And we don't intend to play an active role in any of the other sessions or potential sessions.
And Historic Environment Scotland, at this stage, is it just the cultural heritage inquiry you'd attend? And how many people would you be hearing from?
Thank you, ma'am. Yes, the cultural heritage session, Ms. Hall will give evidence on impact. So, one witness for Historic Environment Scotland, otherwise adopting Mr. Findlay's approach of explaining the full attendance. Historic Environment Scotland would also have a witness speak at the policy session, and that would be Ms. Clements, also sitting behind me. So one witness at that session to talk about the application of policy in terms of the identified impact. And ma'am, Historic Environment Scotland might also wish to make comment on a condition or two relative to its interests. Whether that necessitates attendance at a condition session would remain to be seen, but I should flag that as a possibility for one witness to be in attendance at that hearing session.
Okay, thank you very much. Actually, I'll follow that format. Now we've started it. Mr. Campbell, if you could just run through the sessions that Hofwig would be taking part in.
So far as landscape, thank you. So far as landscape and visual impact is concerned, our present intention is to have a consultant landscape architect and one local witness. So far as cultural heritage is concerned, our intention is the same. One expert witness. I've written two local witnesses in the process document, but actually I think it'll be one. So you're not asking us for duration of these sessions at the moment. It's really quite difficult to predict. So we see what's coming from the other side of the room, but
I'll come on to duration, because we'll have to have an attempt at that at least.
Very good.
Be open to it maybe changing. And your other witnesses for your individually, the hearing sessions you've proposed, you've flagged up likely witnesses in your table. Yeah. No.
We didn't talk about ornithology earlier on. The present intention is, if you're minded to have a hearing on that point, just to call a single witness. on planning and energy policy, a planning consultant who was here earlier but has left, possibly one local witness in addition, although I'm not sure about that. On socioeconomics, there will be at least 2 witnesses. And the only one I'm truly uncertain about is noise, because I've yet to engage with a noise witness who is giving me the advice I need. So I'm sorry, I'll have to come back to you on that.
So in terms of the sessions that I had initially flagged, landscape and visual impact, cultural heritage, policy, conditions, I know that the airport and NATS are both likely to have somebody present at the conditions discussion.
Excuse me.
I don't think any of the other groups that have participated so far but aren't here certainly haven't told me yet that they're aiming to take part. Is there anybody in the room now, and you can confirm this later, you can confirm this in response to the note that I send out, but are there any individuals or community councils, anybody else in the room at the moment who thinks they're likely to want to individually contribute to any of these sessions? Yeah, Mr.
I just wanted to say that, you know, the community councils, we've been working together now for a couple of years, coordinating and cooperating in a way which we have almost never done before this application came in. And I think I can probably say that all of us are, you know, just trying to get up to speed with this process and how it's going to work. And we meet regularly and talk about, you know, what approaches we're going to take. And I think we met last week basically to say we're going to have to feel our way into this, but we will almost certainly want to participate. But we will need to discuss whether or not we're going to turn up, you know, all of us coming or just one of us coming. It will depend on the topics. And we'll have to spend some time just working our way into that. So I don't know what my other colleagues would say about that, but it was just, we can't be that precise, but we know we want to participate, is I think what I'm saying. Sorry.
Yes, and although, as David said, we've been working very closely together on this whole issue for it seems a lot more than 2 years, I have to say. Despite that, there are clearly differences of emphasis in the different community councils. Different issues are more important in Bankery than the issues facing Fins as far as the application is concerned. So I think what we can give you an absolute assurance is that we will make the best use of your time, Mum, and work out a way of ensuring that the community council views are represented collectively and individually, but in a way that's efficient. So you won't get all 6 of us turning up and saying something, so that would be rather boring.
Thank you, yeah, and I think I'm grateful because it's obviously everybody understands what I'm trying to do is include people but not make people feel that they need to repeat each other. And there isn't a perfect answer at the stage on who needs to take part in what, not least because I've still got to decide what I'm going to have an inquiry or a hearing on. The key thing I just need to get clear on today, that I do need to make sure we get right today, is that when we come to assessing how many days we might need for each session, I haven't underestimated that. So I've got space on the timetable to accommodate the people who are likely to want to take part, even if that's, you know, not exactly the same number as we guessed today. So the meeting note will have a request in it for people to confirm within 2 weeks of that note whether they want to take part. And it might still be that you're not exactly sure how you want to arrange yourselves for inquiry and hearing sessions at that point. So my suggestion at that point would be, if you think you would want to be represented, put your hand up at that stage, but I'll be conscious of the fact that you know, some of you might fall away as individuals and align behind others. But if you put your name down initially, then it would mean that if you do find you have got something extra and unique to say, you've still, you know, you've reserved a place, basically. So it's the best fit I'm trying to find at the moment, but I'm grateful to the things I'm hearing about people aligning. I maybe won't dwell too much on trying to, you know, tie down tie down individual sessions at this point. I was going to go through and reiterate what some of the requirements for people are for different sessions, but I think I'll just put that in the note of the meeting as well, because I've gone over it a little bit. There's a bit in the agenda. I don't want to be overwhelming or over-boring people about process. A couple of things is worth saying that I haven't said so far, though. It's more for the applicant, really these. When it comes to the conditions hearing, that will be based upon a schedule of potential conditions that would be appropriate for the proposed development if the proposed development ended up going on and being consented. So the applicant would typically work with the council and others to compile a list of suggested conditions that would end up being appended to my report, subject to any changes I might want to make to them. So I'll just confirm, Mr. Trinick, you're happy to lead on, the applicant's happy to lead on compiling a list of conditions?
Yes, we'll do that, and also on the individual statement of agreed matters, we'll lead on that and draft something for people to look at.
Okay, that's helpful. And just for anybody, sorry, Mandy. Oh, sorry, I can't see you.
Yes, sorry. You asked for individuals who might want to talk. It will depend very much on which evidence you take forward as to how this develops. But if I don't get a chance to speak through other formats, I would like to speak as an individual. Thank you very much. My name is Robin Worsman. And I believe there's other people here as well.
Yes, I'd like to echo that. It's Gareth Brown. Thank you.
Ditto, Leslie Ellis.
Okay, so thanks for raising your hands now. If you look out for the note of the meeting when it comes, and note the date of that note, there'll be a 14-day window for confirming that in writing. So just if you look when the note comes out and just make sure you confirm that in writing, then you'll reserve a place to do that. Okay. And at the back.
Yes, thank you. My name is Mary Bramwell. I'm speaking on my own behalf. I want to ask where or what would be the most helpful forum to present my views on the innate rights and nature of the Hill of Fare and its own right to exist and to be. I don't know where that comes in.
So Hill of Fare is an entity in its entirety. So aspects of that might be relevant to landscape and visual impact. Aspects of that might be relevant to some of the topics that are on the list of hearings that the Hoffwig Group is suggesting, ecology and ornithology. If, when you see the list of suggested discussion topics, hearing and inquiry sessions that comes out in my note of the meeting, if you don't think something you want to say is a best fit with those specific topics, then the community hearing would be a place where you could talk more broadly about what's important to you.
Would you like a written submission about what I have to say beforehand?
I'll come on to that. So there usually are written submissions for formal inquiry and hearing sessions. What we decide for the community session can be a bit more flexible. We do usually have written submissions, just so, for example, if the applicant's coming and I won't want to ask them questions about what people have said, they sort of know in advance what the breadth of the scope of the topics might be. Mm-hmm. People can also put in a written closing statement afterwards just to summarise what they've said. But I'll confirm a lot of that in the note of the meeting. It might be that for the community session, there are some more iterations of that as we go along, as it becomes clearer, what we're doing in the other sessions and therefore what people want to make of the community session. But we'll make sure that's clear for people taking part in advance. Thank you. And I was just going to pick up on what Mr. Trinick said. He mentioned statements of agreed matters. So before we get into any of the detailed inquiry or hearing statements for each of the topics that are being discussed, an applicant would typically look to put together a document called a statement of agreed matters, where if the council and the applicant agree on some matters, that's clarified in writing, so that that doesn't then have to be debated, certainly between those parties, in a hearing or an inquiry. It might be that, you know, some of the objections or the matters that people from the community object to or are in support of go beyond what's agreed, or people don't agree with, you know, with those two parties. So, but that's what a statement of agreed matters is. It just helps to clarify what are the things that are going to most worthy of discussion. It's usually the matters in dispute. So they would typically be between the applicant and the main opposing party. So it would be with the council on landscape and visual matters. It would be with Historic Environment Scotland on cultural heritage matters. Other people aren't generally required to participate in that process. Sometimes they do, but certainly individuals, it's not always really as realistic to expect to find a big list of things people agree on. So that's why we don't involve everybody in that. Has anybody got any questions on statement of agreed matters? No. Okay. So I think that might be all we can get to the bottom of, I think, on this particular topic in terms of who might get involved and what that would mean for the work involved. Anybody got any more questions or points on this before I move on to the next topic, which is the dates, times, durations? Yeah, Mr. Harrington.
Can I just check, so looking at Annex A, we've got this table. Will you, when you write your meeting note up, will you provide an updated version of this then? Okay, and then it will become clearer what's in the hearing and the inquiry category at that point. Okay.
There'll be a final version of the table that shows, based on the discussion today, what I'm going to ask for in terms of writing inquiries and hearings. So when you come to make your final views on what of that you want to get involved in, it'll be clear what's on the table, whereas at the moment it's still a bit up in the air.
Yes, that's what I was thinking. And is that open for discussion then, or is that the kind of final table?
It's a final table. It's my final decision based on the discussions that we've had today and me thinking about that. It can sometimes be, though, that it's not the complete end of things. So occasionally, if there's a written exchange, for example, I might decide that that hasn't given me all the information that I wanted, and I do then need to institute some additional hearing or inquiry sessions. I mean, that's the exception rather than the norm. So I guess the basic question is that my final view? That would be my final view. Yeah, the no. Okay, question at the back.
I probably should have thrown this in earlier. Oh, there's a microphone. Thank you. I'm not very good at this either. Because there's no further procedure against ecology and the ecology, and Nature Scotland and the RSPB have come out and said in their statements that the only thing they've considered is the red kite population. Does that mean that there'll be no more discussion with regard to the impact that these developments are going to have on the bird population and the ecology of the Hill of Fare generally? Or is that something that may change position from no further procedure to possibly something that other people bring up later on?
So that's one of the topics that the Hofbig Group have suggested there should be a hearing session on. So if I decide there should be a hearing session, then it'll be discussed there. If I decide that there doesn't need to be a dedicated hearing session on that, then there would be, people could still give their views on that at the community hearing session. It's just that there wouldn't be an in-depth, bespoke discussion on that.
Yeah, this area is very rich in birds and the like. And there's the pink-footed goose migrate in the winter and the spring every year, and there's about 100,000 of them head down the east coast, and they must fly over the Hill of Fare at some point. So
I've got all that in the written submissions, so I know that there are written submissions on that, and I should say, I think I said it earlier, but I'll repeat it. If I don't have additional procedures now on topics, it doesn't mean I'm not thinking about them. It means that I would make a recommendation on that based on the written submissions before me, both those from the applicant and all of those that have come in from people objecting and supporting the application too. And I can see those geese they have been mentioned. I know they're in there, and they're in this summary from Hofwig as well. Not now. If that's in the written submissions, then that point will have been made, but I'm not taking evidence now.
And Payment and Blacker won't have to either?
Yeah, not now, as I say. Okay. And likely duration for each of the inquiry and hearing sessions. So I have asked parties to set aside the first 2 weeks in September for the oral sessions, whether they are inquiries or hearings. Within that, there'll be some time that we wouldn't use, I guess, generally, particularly if we're travelling, people are travelling to attend sessions in person. We generally keep Mondays free for travel time. And overall, I'd be aiming to finish all sessions by the end of Thursday, the 11th of September, because I think the 12th is a holiday for some people. Each day, so that basically gives us Tuesday to Friday the first week, and if it's in person, Tuesday to Thursday the second week. If things are virtual, the Mondays can be used as well. I propose starting each day 10 o'clock the first day of each week, and then 9:30 on other days, whether sessions are in person or virtual. And I'd be looking to conclude each day somewhere between about 4:30 and 5. So that sort of gives you the overall pool of time that we've got available. Within each day, we would take short breaks in the mornings and afternoons, as well as longer breaks for lunch. And as I said earlier, I'd like to build in some wriggle room so that we don't find we've set aside too little time and have been too ambitious. So with all of that in mind, and we've started to talk about who might be involved, but very provisionally, I'd just like to hear thoughts on how we might sequence different sessions, how much time each session is likely to take, and whether each session would be a virtual session or a session to be held in person. I'm going to start with the council, because I think you've made a suggestion already about starting with cultural heritage. Is that right, Mr. Findlay?
Yes. It certainly, as a matter of my personal diary, would assist the council if the cultural heritage could be taken as the first session, which I understand there's general agreement by those who are concerned with that session. And it may assist if I indicate that, having discussed matters with my own friends, it's likely to be between 1.5 and 2 days, given there are 3 professional witnesses at least. The landscape and visual session, given there may be, there are going to be 3 professional witnesses and certainly, by the sound of things, some input from community councils, I would suggest that you should be allowing 2 days for that. The other sessions, policy is probably half a day's hearing, and that may better come towards the end of inquiry time or the overall hearings. And conditions, it is my experience is that conditions are highly likely to be narrowed down, particularly facing Wright, Johnson, Mackenzie, who are well used to dealing with conditions, to a limited number in dispute, certainly as far as the council is concerned. So that is likely to be less than half a day. But it may, on that timetable, it may mean cultural heritage and landscape and visual take the whole of the first week, and then the second week is taken up with hearing sessions, such as you decide there to be.
Mr. Trinick, based on just on those four events, do you think that sounds about right from your perspective?
Well, first of all, cultural heritage, we agree should go first. That's fine. Secondly, we say that all the sessions should be in person, not virtual. Thirdly, landscape and visual, 2.5 days, 2 to 2.5. Cultural heritage, 1.5 to 2. Policy, yes, half a day. Conditions, an hour or 2. So, total agreement with the council. And obviously, if there are other sessions, well, all bets are off. We just don't know. It could be an extra 3 days.
I'll come on to other sessions, but for those sessions, Mr. Campbell, does that sound like it has enough wriggle room? Yep. Okay, I'm just going to take a minute to have a look at that. Bear with me.
I was saying nothing because I was very happy. Yeah.
Okay.
So, all agreed.
Sorry, I'm just having a quick think about something. Sorry, I missed you there. Okay, so based on those sessions, that would mean setting aside the Tuesday and Wednesday of the first week for cultural heritage, the Thursday and the Friday, certainly, for landscape and visual impact, and if that came forward into the next week and we were holding that in person and having the Monday for travel time, that would mean we were into the middle of Tuesday before we're likely to have finished on landscape and visual impact, which would mean policy and conditions, if we had them on the same day, which is possible but a little bit uncautious, that would be Wednesday, the end of Wednesday, before we got onto any additional hearing time. And if we're not meeting on the Friday, yeah, it's there's only the Thursday at the moment free on that time, that week, unallocated. So for the additional hearing sessions, and let's just quickly go through the list that you put forward. I'm just going to go through them by name, and that's partly because I didn't list them earlier, so people who are observing might not know what topics we're necessarily talking about. Acoustics, wind farm, noise. If we had a hearing on that, how much time would it need?
Sorry, half a day in my estimation.
Can I come in? We don't know there'll be a hearing session. If it's noise, then there will be an inquiry session. I'll be asking for one. Depends on the topics. If we're fighting noise broadly, it's a technical topic, which I think you'll be better assisted by an inquiry session.
Okay, that's true. So as we go through this list, for any that could potentially be inquiry, we just need to make sure we remember that when we look at the bandwidth of how much time it might take.
Well, if it's an inquiry session, it could be a day. Yeah.
Half a day to a day on that topic. Aviation, radar and shadow flicker, Mr. Campbell.
Well, I think I said all I wanted to say earlier about that. If there's a hearing, which is the predicate for this answer, then it's no more than 2 hours.
I'm sorry, I just don't want to miss a note from earlier. Well, this is the key point. Me to
Well, I think
that's why I'm asking you again.
Sorry, I got diverted into the difference between shadow flicker and something else, but if you're to allow a hearing session on that topic, it's half of a half day.
Mr. Trinick, do you?
In other words, it could be combined with something else in a half day.
Okay.
I don't yet know what Hoffig want to say, so I don't know.
Okay. So I'm going to have half day as the best guess at the moment on that. Carbon calculator, Mr. Campbell.
Half a day, ma'am.
Same answer.
Will that be your answer? Do you want me to just go through the list with Mr. Campbell? Is that easier? Let's do radon now then. Radon, Mr. Campbell, how long did you envisage?
For the reasons I gave you earlier, I find this quite difficult. It's a half to 1 day, I'm sorry to say.
And that was the one you had a view on, Mr. Trinick?
Yes, ma'am. I need to know precisely what the case against us is. But if we're talking about emissions to air, that's one topic. Emissions to groundwater are a second topic. Private water supplies are a third topic. I don't know. Let's see.
Okay. Mr. Campbell, Ecology and Forestry.
In my respectful submission, half a day hearing session.
And hydrology, geology, private water supplies, is that the same as radon, which we've just discussed?
I think it could easily be, yes.
I mean, is it the same topic, not the same amount of time?
It's the same topic.
Same topic,
different.
okay.
Yeah.
Then we've got ornithology.
Ornithology as a hearing, with a proper hearing statement, is, in my submission, a half-day hearing. I'm talking about 3 hours when I say a half-day, or 3.5 hours if you start at 9:30, which I think you said you would do on second and subsequent days. Yeah.
Now, I think we're at the margins of the discussion. I don't know what is to be said. We've heard there may be other birds coming into play than red kite. It depends what's said, what the topics are. Do I need an expert witness? If I do, this is not a topic not like noise, where I would expect an inquiry session.
Yeah. And socio-economics, Mr. Campbell.
It feels like a one-day hearing to me. I'm sorry if I'm not being as precise as you would like. It's quite difficult at this remove to be more accurate with how long the evidence would take, because statements haven't been finalised yet. So I'm just really basing this on experience and on the basis that once we start, we'll get on with it and there won't be, untoward delays.
Yeah.
I certainly do what I can to prune the witness list, but there's a limit to what you can do when working with the community group, because so many people want to have a say, and mostly they have something important to say to you. So I just do my best with that.
Yeah, that's understood. The conundrum for me is just that having potential additional hearings to think about whether I need, if I decide I do want to have any of them, I just have to think about whether we, because I think realistically we'd need to go beyond those 2 weeks in September. So I'm just getting a gauge so that if I look for another pocket of time, it's a big enough pocket of time at the outside guess. So, Mr. Trinick, just come back to you just to make sure I haven't missed anything. The ones that you are suggesting potentially would need to be inquiries rather than hearings if we have them, that is ornithology and noise. Yeah. Okay. Thanks very much. No, there's quite a lot of unknowns. That's understood at the moment. Thank you. I'm sorry, I'm struggling to see hands over behind Mr. Trinick.
Mostly people hear my voice anyway, but I'll use the microphone. The lady from ECT, I think, said that they particularly wanted to talk about hydrology. And no, sorry, I thought you said they were having problems with their water supply. Or that was one of the big objections? Am I looking at the wrong person? Frank, sorry. The gentleman said, I knew somebody had said it, that's quite a big topic depending on what their argument is. And it could be quite different to the radon argument. And I wonder, listening, I thought maybe it needs a little bit longer than has been allowed for. but I don't know whether he has a view on that.
I'll just ask you a question first before we go back to Mr Murray. Are you suggesting that we would need to have a hearing on private water supply that went beyond issues relating to radon?
I don't know, but I thought it could be purely that they want that it would interfere, the actual action of placing the pylons could interfere with their... So I don't know. People know better than me, but I just raise it as...
Mr Murray, just based on what process we would need to discuss issues, have you got a comment in reaction to that?
This young lady is absolutely right. It is a big subject. It's critical to the people that live in Mid-Mar, and it is going to take some time to talk about. There will be myself and at least one other witness. The other witness is expert. I think it needs a hearing session.
And just to clarify, that would be witness not on impact of radon on water supply, it would be wider than that.
It's, it's contamination, pollution, disruption of water supplies, the uranium and radon in the water. Yes, it is a broad subject.
Okay, well, I'll note that as an additional suggestion. I think that goes beyond the ones that Hofwig have suggested, and I'll decide on whether I think we need extra process on that and confirm that in the note. I'll note that as an extra suggestion. So coming back to the dates and the sequencing, etc., I think even just one or two of those extra sessions would push us beyond the 2 weeks that we've got set aside at the moment in September. So rather than trying to identify extra time now when the amount of time we're going to need is so unknown, because we don't know which of those sessions, if any, we will definitely have, I will stick to the first 2 weeks in September for the sessions that I had suggested initially, and it looks like we will get through those in that week. We will have to revisit when we deal with any other issues orally, when we know what they're going to be and when we narrow down the focus of any that we do have. So that's going to have to stay up in the air for now. Is that a question, Mr. Ross? Yeah.
Yes, it was just to clarify, it wasn't a discussion about the community hearing and how much time. Obviously, I'm not bothered about how long it goes on. If everybody in Bankery wants to come and speak to you, that would be great. But I would to give that enough weight and enough significance, because for it to be not just an addendum to the process, but so that people can really be heard. Thank you.
You're right, and I would want to accommodate that within the original 2 weeks, because I think that's a key part of the process that I know is going to be important for people. So I'm just going to quickly remind myself how full those 2 weeks were. So at the moment, I think those 2 weeks had filled up as far as midway through Wednesday, at least, of the second week, which would mean possibly, I think people have said they prefer an evening, that maybe the Wednesday evening might be a possibility, or the Thursday at the moment's free. If people needed more time and that needed a whole day, then Thursday would be free. But I do get the impression that an evening is strongly preferred for people who are working. Have you got a comment on that, Mr. Campbell? The question is, looking at the space we've got left within those first 2 weeks in September, where would we best fit the community hearing session? Would that be better on a Wednesday evening or possibly in a daytime on Thursday, do you think?
It would be better on a Wednesday evening. And I think it could conveniently be in the second week. Don't you?
Yeah.
Yeah, and anybody have any strong problems with that if that's what we went for? Okay, Mr Trinick, if I want
Sorry, may I just... I don't have a strong problem with that, but as long as we're not talking about a token, and I'm sure we're not, a token effort one Wednesday evening, that it's given a proper time and not constrained.
Go on, if it helps you, Mr Ross, till 9:30 at night.
That would be perfect, thank you. Longer.
It's not. It's a law of diminishing returns after about 9 p.m.
Mr Morris.
Yeah, I'm just wondering whether there's any thoughts, ideas, experience, guidance on how we could best set the community up for that.
I mean, I can provide guidance and steers. I can give examples of different community hearings that have happened before, because there might be different formats. It would depend on who wants to take part and what ultimately we're looking to cover. I know Mr Campbell's been involved in some sessions before, and I have, so we can certainly put together some examples. And as we get closer to the time and it's clearer what's being covered elsewhere, if there's additional guidance that I will steer that I can give to people on preparation, then I would do. It's hard to sort of set that out perfectly now, but certainly it's designed to be flexible. It can be designed around the people that are going to be trying to make use of it, basically. So there would be, but I couldn't sort of paint a picture of what that would look like just now.
No, thank you. Just anything that helps us set it up, really. Yeah.
In terms of whether it would be token or not, when I say an evening session, it would be the equivalent of a half-day session, really, but set in the evening. So, you know, looking at around setting aside 3 hours. When I've had sessions before, that's tended to be the time set aside. Often people don't, you know, get to the end of what they want to say before that, but it would be set aside enough time. Mr Trinick, if I wanted the applicant to be present and able to answer questions that I might ask of you based on what I'd heard, would the Wednesday evening that week be available?
That would be fine, or indeed we were thinking the Monday evening.
It was the Monday evening.
Of the second week.
Yeah, that's true. So Monday I've set aside the travel time, but that doesn't mean it's
Evening. And that means that those of us who are in the inquiry and turning up on Thursday after a long evening, Monday might be better.
That's a good point. Would Monday be equally okay with Mr Campbell and others?
Just to add to that, you did give links in your agenda to previous examples of community hearing sessions.
I did. So you'll be able to find those in the agenda. There were 2 really quite different sessions that I gave links to the recordings of. One was the session that I was involved in last year in Argyll, where there were a small number of community participants. So they all had quite a bit of time each. That was, from memory, a community council, a group that looked after a local right-of-way, and a local landowner. I used that time. It was a full room of people listening, but they were the participants, and I had the applicant there answering some questions. The other was a session I wasn't involved in, but Mr Campbell was, where there were a lot more people taking part. So people had less time individually, but probably covered as wide a range of subjects. So those are 2 different examples I've put in the link. If I can find more that might help, then I can send those around. Here, I think it's probably likely to be in between, you know, more than 3 people, but still with some distilling around groups. Mr Campbell, have you got a comment?
I'm sorry for sneezing so much. It's the hay fever season. The essence of these sessions is that people are expected to write down what they want to say in advance and let parties see that in advance. People should be reassured that there's generally no cross-examination, but there may be questions by the reporter. And there's limited scope for supplementary material from the witnesses who are speaking, but only limited scope. So it's not a free-for-all, and it's certainly not a across-the-floor discussion. If people understand that and can be made to write down what they want to say, then it generally works quite smoothly.
Yeah, that's all true, and we'd work that into the instructions and advice that come out beforehand. Mr. Findlay, had you got your hand up to speak?
I did. I was going to make the same point that Mr. Campbell has made. I've been involved in a number of evening sessions, and I'm happy to speak to any of the community councils afterwards, but I would perhaps suggest that sometimes weight of evidence, the same number of people saying the same thing loses its impact, but no doubt there'll be a significant overlap between various witnesses, but having it written down in advance helps the witness primarily, in my experience, because they don't think they need to make it up on the night, so to speak.
Yeah, those are all good points that both gentlemen have made, and as I say, we try and sort of crystallise some advice beforehand in terms of what comes in before in writing, how the time's organised, and who's speaking on what. So we don't need to clarify all that now, but we will do as time moves towards that. Sorry, my mic was off. Would Monday evening in the second week be equally suitable to Wednesday evening if we went for that option that Mr. Trinick had suggested? Yep. Okay, that's good. Thank you. I'll clarify which one I'm going to go for. Okay, so as I say, I think we've filled up those 2 weeks. Mr. Harrington, sorry.
I mean, the only thing in my mind is that if it's later in the process, then, you know, you've got the benefit of having heard what's been said so there would be a slight preference for the Wednesday for that reason, from my perspective.
Okay, so the extra thing you'd have heard would be the very back end, or the last section, I should say, of landscape and visual impact. So I take your point. But ideally, you know, by the time you get to that point, we'd have had in writing from people what they're going to cover. So it shouldn't be such an issue. You're not relying on hearing that to know what you're coming to that meeting with.
Yeah, okay. Yeah, it's a marginal thing, but a slight advantage.
So to come on to the venue, so for today's meeting, providing it turns out the IT issues aren't down to the venue, otherwise this venue's been good in terms of sound, I think, and in terms of the space that we've got for people. So we think, Mr. Yep. Okay, so the proposal would be if that's, it looks like the room's going to be available for those first 2 weeks in September, so I would suggest we use this room then. In case we need a plan B, people now or just by email after the meeting could put forward any other suggestions if you have them, just in case they're needed. And in case we end up needing a different venue, if we have any further sessions, is there anywhere anybody wants to suggest initially, or are you happy to do that later? I'll just take a show of hands. Okay, so as I said, just feel free to send any other suggestions in for us. Mr. Trinick, for these sessions, I think you said you would think it would be best to have them all in person. I think that was including conditions and policy in this instance, which are often virtual. So you were meaning those as well. Policy and conditions sessions are often virtual, but you think in person. Okay, and Mr. Finlay, you'd agree with that? Historic Environment Scotland, would that be okay with you? And Hofig? Okay, thank you very much. Okay, so I think that's everything we...
Ma'am, there is one exception to that, and that is contingent on what happens about these other issues. Because if you decide oral process is necessary and in-person becomes difficult, but virtual is possible, while keeping to a certain timescale, that might be a possibility.
Yeah. And I was going to suggest leaving those as a to be decided based
so.
on where we get to with the initial thoughts on what's happening. Okay, so just to clarify that discussion for everybody, the landscape and visual impact, cultural heritage, policy, conditions and community hearing sessions will take place in those first 2 weeks in September. I'll confirm what's happening on which dates in the note, and they will be here in the local area, ideally in this location in person. Okay. Any other oral sessions, all of that detail will be decided, and they would happen at a different time. Okay, I would suggest before we come on to the timeline for submitting documents, which I know we're going to have to muck about with a bit from my suggestions, we'll have another short break and then come back. Do we think, because I hadn't realised quite how into lunchtime we'd got, do we think we can get through that relatively quickly, or should we take a longer break for lunch? What do people think, Mr. Trinick?
Frankly, my vote is not to have a break at all, but to continue and finish. I don't think it'll take us that long.
I agree.
You agree, Mr. Finlay? Okay, I'll just check. I've got some water. Okay, I also agree on that basis. Okay, we will move on to the timeline for submission of documents. Just something I shouldn't forget to tell you. I mentioned in the agenda that DPEA is currently updating guidance on document management. There's going to be a new guidance document coming out very soon on how we manage inquiry documents. The aim behind that guidance is to make sure we have proportionality and efficiency, and that we reduce the submission of unnecessary documents that aren't explained or relied on in written and oral evidence. If we get significantly more documents submitted to us as a comfort blanket, essentially, then people end up using it. That does cause quite a lot of extra work for reporters who have to read them, and for case officers that have to process them, post them, file them, etc. And having a sea of unnecessary documents online can make it quite overwhelming and difficult for third parties, any parties really, to look at what's in front of the inquiry and what they might want to comment on or add to. So the document isn't out yet. When it is, I'll send that round. We're expecting that guidance document to be out by the end of, well, by the time I circulate the meeting note. One of the things that people who are regularly involved in inquiries will see is just some changes in the language. So I think we talk about document lists in it rather than core document lists, which is why I haven't got core document lists mentioned anywhere, hopefully. Something that's not changing, though, is it will remain really important that parties give each other and me prior written notice of their arguments before any hearing or inquiry session, and that's really to avoid any party getting surprised or caught out in a session itself. We've talked about making sure these sessions are hospitable for everybody. So, we need to, that's a big part of the spirit of that, and I wouldn't allow people to be surprised or caught out anyway. So when the time comes, each party taking part in either an inquiry or a hearing session will be required to submit a written statement. I put an indicative deadlines for that work in Annex B. We'll come on in a moment to that annex and see what changes, if any, we need to make. When people, before a hearing or inquiry session, submit an inquiry or hearing statement, there isn't a word limit for those statements. The key point is that they serve their purpose. So they need to outline parties' cases, give the names of the people who are going to be speaking at the session on, and broadly what topics each person is going to cover. And those statements will also list the documents that each party or person will be relying on in evidence. Something, again, like conditions, like statements of common ground, it's typical for an applicant to work with other parties to compile a single document list, so that when we're in an inquiry hearing session, you'll find certainly I and other parties need to go and look at certain parts of documents. If we've got one list with links to everything, that makes that a whole lot easier for everybody and avoids sort of delays or annoyance as well. Mr. Trinick, are you happy to lead on documents?
Yes, ma'am. I've also just got a question. What you were describing there is more the nature of a statement of case as opposed to an inquiry report. but there's nothing in your Annex B about statements of case as such. Maybe I misread.
No, I'm meaning to talk about inquiry and hearing reports, so I will check how I describe them and make sure in the note, if if I need to give a better description of those, then I will. The main point I want to get across now is that there is some written work for parties to do before inquiry or hearing statements, and the purpose of that is that everybody can prepare well for those sessions. Okay. So you've confirmed you're happy with the document list. As I said, we're sort of evolving the way we deal with compiling documents lists. So the case officer will get in touch with you from time to time, and they're going to play a role in putting together as much as possible to give you a good starting point on that. So Hazel, the case officer, would get in touch. The applicant can't do that on their own. Obviously, they need quite a lot of cooperation from other people taking part to make sure you make your decisions on time about what documents you want to produce or rely on, and pass those through to the applicant in time for them to meet the deadlines that they've got for that work. So I've got some key dates for that in Annex B, and as I say, we'll come and look at those dates shortly. At the moment, I've only got, I think, final deadlines for the applicant to be producing the draft and final documents list. So if you think extra deadlines need to go in for anything that's happening between parties to support you meeting those deadlines, then that'd be something to think about when we get to the list. Another important document that people need to provide if you are taking part in inquiry sessions, so if we do have inquiry sessions on anything, after inquiry statements are provided, each individual witness at least 2 weeks before the inquiry session needs to submit what's called a precognition. And that's a short, well, it's a word-limited, 2,000 word-limited document where you sort of crystallise your case and should reflect what you go on to speak about in the inquiry. So doing documents can be obviously harder work. So if people do want to just rely on inquiry statements and not do a separate precognition, you can, but that would mean that your earlier inquiry statement would need to be within 2,000 word limit. So you either can have an unword limited inquiry statement plus precognition, or just one document, but that would have to meet the 2,000 word limit. And as I say, the precognitions have to be in no more than 14 days before the start of the inquiry session, and that's quite a hard date. So I'm just flagging all the dates are important, but that is one of the particularly important ones. Another form of documentation that will come and go is further written submissions. My note of the meeting will confirm the information that I'm seeking, who I need it from, and when by. I've said here very boldly the deadlines will be the same as Annex B. They won't. They'll change. So there's a few things that need to change. Firstly, those dates will probably stand for most of the initial questions that I'd flagged, because I know what those questions are going to be. I don't need to sort of compile them. The aviation interests have asked for a bit more time for the question I flagged on radar. I think that just pushes that question and response time back by a couple of weeks, so that's one that will change. In terms of formulating questions to get the additional information from Mr. Campbell's group that I need in order to be able to take views from the applicant and others on whether we do indeed need hearing sessions on those. There might be slightly different timetables for those. It'll depend on what I think we need to ask. They're slightly different types of questions, I think. So where I've got a question arising from evidence, I'll have a specific question of what I need. I know who I want it from, and I give them, time to respond. For the questions that are going to crystallise whether we need additional hearing sessions, they'll be slightly different in nature. It would be asking Mr. Campbell to clarify the issues in contention and why a hearing session might be particularly helpful on those. So they might have a different timeline to a more straightforward question. And Mr. Trinick, I think you said you were going to ask for a variation on the basic dates I'd put down.
Yeah,
I also add that if the council is to obtain a new landscape witness, I would be supporting the requirement to move that date back, if possible, to give that witness time to do the necessary work. So whether 4 or 6 weeks before, but probably prefer 4. But
4 would be our preference.
Okay, I'll think about that. If you look at Annex B of the agenda, which was my initial timeline, and see what some of these changes do to that. So some of the dates in here are contingent on the date of this meeting. So there's some key dates that are based on, weeks out from this meeting. And then towards the end, other key dates are based on working back from the run into the inquiry time. So let's just see if we can run through it. So examination meeting has happened today, like just about. The next date in there is the 2 weeks from the note, the note coming out, which is next week. 2 weeks from that note, I want people to give me their view on whether they're going to be getting involved in hearing and inquiry sessions. As I said earlier, if you want to give me a safe bet and put your name down initially, then just do that, and that can be refined. It can be refined down later. You can't add yourself if you weren't there later. So I had asked for, by Friday the 2nd of May, further written submissions. So already that's one we're looking at changing the date of. So I don't have my computer on because my Wi-Fi didn't work. So that was based on 3 weeks' time. Is that right? No, sorry. I just talked myself round in a circle. I'll come back out of it in a moment. I'm looking at the date for when I was going to do the meeting note and ask for the written submissions. That'll be the same. That'll be the Friday, the 2nd of May, possibly a couple of days earlier. The date I think I'm talking about is when you give me the further written submissions that I've asked for. That's down the bottom of that first page of Annex B. I had that down as Friday the 23rd of May. If that was moving from 3 weeks to 6 weeks, where does that put us, Mr. Trinick? I don't know if you've timetabled this out. Yeah. The 13th of June. And the comments from people would come back in. So typically people responding to further written submissions have 2 weeks to do that. So that would be the 27th of June, is that right? So, yeah.
That clashes with a public inquiry in Skye, which Mr. Finlay and I are involved in, which is scheduled to start on the 23rd of June and to run for a week.
If I stuck to that date, you'd only have that first week to put in any comments on the further written
If that's your
submissions.
decision, I'll deal with it, but it's just,
Yeah.
you know.
A lot of the further written submissions would be ones, I think, where you would be the initial respondent
Yeah.
rather than coming in later, but I'll bear that in mind. Mr. Finlay, do these dates cause you trouble?
Okay, and I acknowledge what Mr. Campbell says, but we'll have to deal with them. I'm certainly not subject to the issue of our landscape consultant. If we need a new one, then I don't have a particular problem with any of these dates.
So I'll ask a question, Mr. Trinick, of you, and I probably should have asked it earlier rather than just starting to go into the profiling. So is there a particular reason? Because your request to change from 3 weeks to 6, I think, was just based on was that based on having seen my original suggested further written submission topics, or is that a response to the additional ones?
The latter.
The latter.
We can deal with yours within 3 weeks.
So if I had 2 sets, some coming in earlier and
That's
some a bit more protracted, would that be fine?
Yeah, you can stagger them, that's fine. Sorry, radon was on your list. That one does require 6 weeks.
Okay.
Yeah.
So that was going to be a question asking you to comment on the discussion on that that's come through. So you would need 6 weeks for radon.
Going back to Annex A for the moment, for radar, well, we're seeking to reach agreements and we can comment within 3 weeks quite easily.
Yeah.
On shadow flicker, we can comment within 3 weeks, except that that's a no. Shadow flicker is a case where Mr. Campbell wants a hearing, so I think that puts that into the second category of submissions to which we will respond when Mr. Campbell comes forward with his reasoning for a hearing session.
Okay. If I ask that question.
If you ask that question.
Yeah.
On radiation, again, that's in the Campbell category as opposed to your category.
Okay. So my category of radon would be comments on what's already before us on that subject. The shadow flicker, my category of question would be comments on what some people have said about the suitability of the methodology that's being used. So those two questions, if they were just within those parameters, would 3 weeks be enough?
That's enough, but I'm not sure they deal with the real issue, which is how we're going to deal with radon and radiation as part of the inquiry overall.
Okay, so I'll bear that in mind.
Yeah.
Okay. I'll come back to the timeline. So certainly for some further written submissions, we'd be looking at not being at the end of that process until the 27th of June. That starts to overlap with the beginnings of the process for leading into the inquiry and hearing sessions for September. Particularly that would sort of jump beyond the initial documents list date. And it would come up, well, it would come up a little bit closer to inquiry and hearing statements, but we've already discussed possibly moving those back by 2 or 4 weeks. So is there any other reason why the further written submissions finishing on the 27th of June would upset anything else that people are doing on that timeline? Mr. Trinnick, can you see anything?
No, I think that's okay.
Okay, and Mr. Findlay? No. As far as you know. Okay. Okay. So moving forward, we start. Before I move forward, obviously, depending on what comes out in the wash from those further written submissions, there would maybe a need then to regroup and see if we need, if I don't think that what I've got in writing can stand for itself, and I need to discuss it. We'll have to realistically, we'll have to reconvene again and time that out, Mr. Trinnick.
Just thinking this through again, if you push back hearing statements and inquiry reports until to 4 weeks before the inquiry, that's the 1st of August. That gives all parties, should you decide on a hearing session for some topics, sometime after the 27th of June. That's not a lot of time to get evidence together, 1 month. I'm just wondering, looking at Mr. Campbell, whether you'd be in a position to advance your reasons for wanting a hearing session on the relevant topics quicker than 6 weeks from today's date.
Before Mr. Campbell answers that, I wasn't suggesting applying any of these dates to any additional hearings that might arise after we've looked at those further written submissions. These are just for those September sessions that we know when they're happening. So I think we would realistically, when I've seen what comes in from those, the further written submissions relating to the Hofwig process suggestions, we would need to, if I was thinking about constituting some additional hearings or inquiries based on that, the relevant people would need to get back together, I think, for a further pre-examination meeting and decide how we were going to timetable that in, so that shouldn't overlap or interfere with the preparation for the sessions we know about. Okay. So apart from then giving people a bit of extra time for the inquiry and hearing statements for those original list of events, are the subsequent dates on that timescale, timeline still okay? Mr. Trinick, yeah. Mr. Findlay?
Yes.
Okay, that's good. The only thing I will need to look at carefully in seeing do I definitely agree to moving those inquiry and hearing statement dates is whether that would reduce our ability to implement our new approach to document management. I'm sure it won't, but that's just something I need to look at, because I think there are some new timelines, standard timelines in that guidance that I'll just double check. But okay.
Can you foreshadow what it might say?
I can't foreshadow what it might say because I wouldn't want to get it wrong, because it's already been quite a confusing discussion, but the guidance should be out in time for me to circulate it with the note of this meeting next week. Now, I've already worked with colleagues who were working on that guidance to try and align my procedural timeline to it, so it works with it. I don't think these changes would be problematic. I'm just saying that, you know, I will double check that we'll still be able to do good project management if we make these changes. I'm sure we can. Then. So I think that's probably the dates done with. I hope I have recorded that very neatly. And if I do need to double check anything or anything doesn't look like it aligns when I rewrite that out, I might ask for the odd bit of input, but I should be able to reprofile that fine now based on what we've decided would work today. So anything else on documents and timelines before I move on to item 9? Mr. Ross.
Just to apologise, I have to leave now, but thank you very much, and I'll look forward to your note.
It'll be an excellent note, I'm sure. Just as you're leaving, you'll be interested in the next item. It's site inspections. As set out in the agenda, I intend to undertake unaccompanied site inspections before the inquiry and hearing sessions take place, so that when I come to the landscape and visual impact and cultural sessions, I am much more familiar with the area and with I've looked at the evidence in that context in the field. So I'll be planning to do that probably June and or August before those sessions. If it proves necessary after we've had the inquiry and hearing sessions, there is scope for me to do in further site inspections, either accompanied or unaccompanied, but I'll decide on whether I need those further site inspections based on how those discussions go. In the short term, if parties want to make sure I put any particular locations on my initial site inspection list, then you can either mention them today or ideally email those into Hazel at the office and let us know. I'll be planning that site visit out between now and June. So if you make suggestions in the next couple of weeks, I can make sure I've got those covered and looked at them.
I think Scolty Hill is the one that's missing, if I remember correctly.
Well, that might not be the only one.
It may not be the only one, but that's a very obvious one.
Okay, thank you. Yeah.
Ma'am, if I may just, on behalf of Historic Environment Scotland, make a suggestion for your consideration. Historic Environment Scotland appreciates that you're intending to undertake these site inspections June, September. You may be aware, ma'am, from reading in that you've done so far, that there are trees located within the vicinity of both of the scheduled monuments which are affected, and leaf coverage may be discussed at the inquiry session. So, from visiting both of the sites yesterday, I could see the leaves are coming in, particularly at the Christchurch Stone Circle, the trees there, but the leaf coverage is not yet complete at either of the sites. So, ma'am, whilst you're in the locale, we would like to suggest that if you do have an opportunity to go this afternoon or whatever to have a look at both of the scheduled monuments, that may be of assistance.
Okay, and yeah, I guess otherwise I'll be looking towards after the summer, when the leaves start to fall. Okay.
Yeah, which might not fit with when you're intending to finalise your report or whatever. If you've got very little time, the sites are nearby. They're both close to each other and are very accessible from the public road. And what Historic Environment Scotland would suggest is that what you prioritise is standing in the centre of the stone circle and looking over the recumbent stone, the stone which is lying flat, as opposed to the upright stones, and look at that view. That would be helpful. From the centre of the stone circle, looking over the recumbent stones towards Hill of Fair.
Thank you.
Thank you,
Ma'am, could I...
yeah, Mr. Murray.
Could I support what Historic Environment Scotland has just said? My home is close to Christchurch Stone Circle, immediately adjacent to it, and he's quite right. Just now, the trees are begun into leaf. In the time that you're intending to look at them in September, they're probably still going to be in full leaf. It would be very helpful if you could look at them whilst you're here.
Not September, that's when the session is, but it would be June or August, so I've seen them before, but the same point, I guess, would be true regarding the leaves. Okay, thank you for that. Next agenda item is item 10. These are just, we're in the closing stages now. DPEA website and contact. So the best way to keep up to date with proceedings on the inquiry will be through the DPEA website. All of the documents that are submitted will be there for you to view. My note will go on there as well when it's posted round to people. I'll include a direct link to the section of the website that covers this inquiry case in the meeting note. The DPE case officer for this application is Hazel Bailey. I think a lot of you have probably been in contact with her before. She's very good, very fast at getting documents up on the website. So if you track the website as well as your inboxes, you know, you're less likely to miss something if something ends up going to your junk box, which I know sometimes has happened already. I'll put Hazel's contact details in the meeting note for anybody that doesn't have them already. They are already on the meeting agenda. Any discussions or questions that you need to have would be with Hazel directly. I can't communicate with anybody directly myself in between, you know, outside of the actual inquiry and hearing sessions. Item 11, a note of the meeting. So as I've said, I will put together a note of the meeting today. I'm aiming to have that out midweek next week, but the Friday next week at the latest. The note will confirm my decisions on all of the matters that we've discussed today. So that would include what further written submissions I want, from whom, and with dates for submissions, and including clarity on what people need to do if they want to comment on what they see in those submissions. I'll put in decisions on what topics we're going to be dealing with by hearing or inquiry sessions. The final decision on that's going to be based on the ones I'd originally suggested. A final decision on any additional ones will wait till after we've dealt with some of that in writing. I'll put in the revised dates for, that were in Annex B. That would include revised dates for when people need to submit things in the run-up to hearings and inquiries. And I'll put the other key dates in that as well. I've already mentioned this, but it's really important that within 14 days of the date of the note, though not the date that you see the note, but the date, I put a date on the note, within 14 days of that, people do have to confirm to DPE in writing, emails fine, which, if any, of the hearing or inquiry sessions they want to participate in. And it is best, I would say, to be putting your name down provisionally for any that you think you would want to feed into, whether or not eventually that's likely to actually be you or somebody else that you're working with. Because, as I've said earlier, you can take your name off the list later. It's not as easy to put your name onto it as a late addition. So, as I say, keep your eye on your inbox and your junk inbox and the DPO website so you see the meeting notes and you don't miss that important deadline. Any questions on that? Rego? Yeah, Mr. Harrington.
Can you just attend as an observer, or do you?
Yeah, they'll all be in this room or a room like it. And whether or not you've said beforehand that you're interested, you can just come and observe on the day. Observers can't then decide they want to speak, but observers are welcome.
Thank you.
So the final agenda item, item 12, other relevant matters. One thing I just wanted to flag is a few people who aren't around the table, people over on this side of the room, I've got your names, so I can list you as people who have attended and participated. If you have spoken today and you haven't, when you came in, you didn't flag yourself to Mandy as somebody who wanted to speak, if you give her your name, I'll be able to include in the meeting note that you participated. If you don't, I won't. But so if that's important to you, and it would be good for completeness, give your names to Mandy. I did forget, as people were speaking, to ask you to confirm your name, so that's extra admin for you, and with my apologies. I want to thank people particularly for patience at the beginning of the meeting. We will do some work between now and September to make sure we can start on time, and the IT works in its ideal way for those sessions. But thanks very much for being patient while we got started. Are there any other questions at all that people would like to ask me while I'm here? Mr. Findlay.
It's just to make a point that if you're going to have a further pre-inquiry meeting, can I suggest that certainly I'd be happy for that to be done virtually if others are, rather than having to attend here.
Yeah, I'll note that as a preference, and that'll be finally decided at the time, but I can note that as a preference. And we will obviously not know until later who the parties might be to that, but certainly if it's mainly Mr. Campbell, Mr. Trinick, then that would make sense. Any other questions? No. So I will just thank everybody very much for coming out. I'm glad, having come up to Banbury for the meeting, that there were so many people here, and that a lot of you have said your piece on the things that you wanted to. I really appreciate that. It helps inform how we run things, and know it's good to know now that there's a good appetite from the community for things happening in September. And I will look forward to seeing those participants then. Okay, thank you very much.